begin the talk in just a few minutes. We'll give folks a few seconds to come into the webinar room. So I think I will begin now. So good evening, everyone. My name is Nagai Pendel, and I'm the Dean of the Allard School of Law. Before we begin tonight's program, I would like to acknowledge that UBC's Vancouver campus is located on the traditional, ancestral, and unceded territory of the Musqueam people. I would also like to acknowledge that you may be joining us today from many places, near and far, and acknowledge the traditional owners and caretakers of those lands. Before we begin, I just have a few housekeeping issues. So one, if you experienced any technical difficulties, please reach out via Zoom chat for assistance. Please be sure to direct your questions to the host. We have additional colleagues on the line whose webcams are turned off, but they are assisting on the back end. And also, if you have any questions, please use the Q&A box to submit any questions for our speaker throughout the webinar. So I am honored today to welcome all of you to the 18th annual Marlee Kline Lecture in Social Justice. This evening's lecture is entitled The New Sex Wars, Sexual Harm in the Me Too Era. And we are very fortunate to have with us Professor Brenda Cossman from the University of Toronto as our speaker. This annual lecture honors the memory of Marlee Gayle Kline, a member of the Faculty of Law from 1989 until 2001. After losing Marlee far too soon, her colleagues, students, friends, and most especially her family joined together to establish this annual lecture. Marlee's work on feminist legal theory and critical race theory, child welfare law and policy, law's continued colonialism, and restructuring of the social welfare state is internationally acclaimed. Marlee insisted on a complicated intersectional understanding of the law and the world. This lectureship not only recognizes Marlee's rich contribution to the law school community, but it also reflects her passionate belief in the central role social justice concerns must play in legal education and law. So for tonight's program, Professor Cossman will speak for roughly 40 minutes, followed by a question and answer period moderated by Professor Regine Tremblay, Assistant Professor and Director of the Center for Feminist Legal Studies. And I will now pass the microphone to Professor Margot Young, professor here at the Allard School of Law, who's affiliated with our Center for Feminist Legal Studies, and she will be introducing our speaker. Thank you. Margot?
Thanks, Dean Pendel. It's a real pleasure for me to have a small spot in tonight's events. As the Dean said, I'm a professor here at the Allard School of Law, but Marlee was one of my best friends. And indeed, Brenda, tonight's guest, and I were both close friends with Marlee, and Brenda and I have remained dear friends ever since as well. Now, on Brenda's urging, I'm going to say less about her and more about Marlee, but you have Brenda's bio in the poster and other materials around this lecture. I do want to say very briefly, however, that Brenda is a renowned feminist legal scholar, author of many books and articles, and a leading thinker in the fields of law, feminism, and sexuality studies, from her perch as a professor and as the Goodman Shipper Chair at the University of Toronto Law School. This talk flows from Brenda's most recent book, The New Sex Wars, Sexual Harm in the #MeToo Era. So we sent Brenda down into her basement to hunt up some photos, and here they are. We're sharing a screen with you, and you can see that there are some photos of the three of us, Marlee, Brenda, and me, and then one on the slopes of Brenda and Marlee. And, you know, I mentioned that Marlee, Brenda, and I were very tight friends. And I'm going to tell you a bit about what's special for me about Marlee, a piece of the huge amount of stuff that's special about Marlee for me. And then Brenda's going to do the same. And then I will turn the virtual podium over to Brenda. Marlee was, simply put, remarkable. She was a complicated mix of softness and hard resolve. And as a friend, she was simply a delight. She had an infectious, ready laugh that almost, but not quite, came out as a guffaw. And she was fun. She was engaged with and amused by the small, inane things of life. She was also a serious thinker and cared deeply about justice and about social justice. She was a much-loved teacher. When she died, it was most commonly said about Marlee that she spoke truth to justice. She was fierce in her intellectual integrity, and her scholarly work continues to resonate. She was determined, as she showed in her work, in her friendships, and also in her struggle with leukemia. Marlee loved fully. She loved her friends, her family, her partner, and she especially loved her son, who was the joy of her life. This talk reminds me and many of us of Marlee's deep commitment to social justice on big and small scales, but it also, for me personally, invokes rich and deep feelings about Marlee's spirit as a teacher and scholar, as a friend, as a daughter, and as a sister, as a partner, and as a mom. Brenda, I'm going to turn it over to you to say a little bit about Marlee from your perspective.
Thanks, Margot. So, to this day, I still use Marlee's work in my own work. Her brilliant academic spirit remains so alive in me as it is in so many others. As I'm thinking, I often think, what would Marlee think? But Marlee was much more than just a colleague. She was my friend, and she was one of those close soulmate kind of friends that you're lucky to make once or twice in a lifetime. She was so many things wrapped up into one. She was brilliant and kind. She was filled with outrage of the state of the world and incredible love. She was equal parts serious and really, really silly. We would spend, in the time we spent together, which turned out to be all too short, was spent with, equal parts intellectual engagement, fierce debate, and hysterical laughter. And we often, did all of these at exactly the same time. Now, in many ways, Margot and I continue that intellectual engagement and hysterical laughter, but we miss Marlee so much.
Thanks, Brenda. And you can see from the slide that Brenda put up that, one of them is us hanging out for dinner at Marlee's house. And it was just a great, rich, wonderful personal connection that we've both had with Marlee. So my role's done here. And all that remains for me now is to turn the floor over to Brenda. Brenda, welcome. And I want to finish my remarks by saying just how apt it is and wonderful it is that you're delivering this year's Marlee Kline Lecture in Social Justice. Thank you.
Thank you, Margot. So, people often start their talks. Sorry, I'm just putting on my timer. People often start their talks by saying how honored they are to be here. But the thing is, I am so honored to be here. I'm so honored to be here because of my relationship with Marlee, because of the closeness that I had with Marlee, because I still miss her so very dearly. A single lecture cannot begin to do justice to her memory, though I do hope that my words today can in some way honor her. And one of my biggest challenges is to actually get through the lecture without crying. But frankly, I think, even if I did, Marlee would have told me that that was okay. So let me start. Let me start by trying to get my slideshow to work. So my talk today is based on my new book, The New Sex Wars: Sexual Harm in the Me Too Era. The basic argument goes something like this. When it comes to the legal regulation of sexual harm, feminists have been having the same arguments over and over and over again since the sex wars of the 1970s and 1980s. And basically with the same underlying disagreements about sexuality, women's agency, and the role of law. These debates continue today, and it's time to stop. I suppose I could end there and say, thank you for coming to my TED Talk, but I will actually, continue. So my project started just before the viral eruption of the Me Too movement. I began looking at a series of feminist debates and looking at the ways in which some of these feminist debates, the way feminists were disagreeing with one another, were dividing along all too familiar feminist fault lines, whether it was around issues of sex work or so-called revenge porn, or sexual harassment and sexual assault. These were debates between and amongst feminists that were dividing along lines that seemed very much to me like the old sex wars, at which point I coined a term calling them the new sex wars or sex wars 2.0. Then I was already starting this. Then along came Alyssa Milano's tweet in October 2017 on the heels of the revelations about Harvey Weinstein. The tweet unleashed an astounding outpouring of women coming forward and saying, yes, it happened to me too. Within days, millions of women from more than 85 countries had publicly said, me too. Now, Marlee would have been the first to point out the fact that the Me Too campaign was actually created by Tarana Burke in 2006 to support Black women and Black girls who were survivors of sexual violence. Within a few days, Tarana Burke had been appropriately credited as its creator, but the hashtag movement took on a life of its own. The hashtag Me Too really developed in a way that I think is quite different from the Tarana Burke Me Too, which is something that I do take up in later parts of my book, when I also try to bring Tarana Burke's Me Too back front and center. Within weeks and months, powerful men fell from grace. Harvey Weinstein, Charlie Rose, Matt Lauer, those are only a few of the names, all lost their vaulted positions as stories about the sheer ubiquity of sexual violence proliferated. But even as Me Too was still picking up steam, and it was picking up steam, it started to meet some pushback. The pushback went something like, Me Too was going too far. Although what too far meant was not particularly agreed upon. It was a sex panic, or it was a witch hunt, or it was the death of due process. And this was, many thought, the pushback. It was simply the kind of conservative reaction to Me Too. The objections came from across the political spectrum, but there was also a very distinctively feminist version that began to emerge. Not from the conservatives, but a very distinctively feminist voice. It first came in whispers, a kind of sotto voce, and then it got a little louder. And eventually, sorry, my slides. Eventually, this was the dissenting feminist voices. The simmering came to a boil with the publication of a story about Aziz Ansari in an online journal known as babe.net. Now, the article told the story of Grace, not her real name, a 20-something woman who went on a date with Aziz Ansari, where he repeatedly initiated sex with her over and over again, despite her discomfort and her request to slow down. It started, it stopped, it started, it stopped. She eventually leaves in tears, and she comes to understand the encounter as an assault. So following the publication of this story in not a particularly mainstream platform, the feminist internet exploded. The story, broke the feminist internet. And the story resonated for many young women, not exclusively young women, but particularly for young women, whereas many others denounced it as trivializing what Me Too should stand for. And it was with several self-described feminists writing in very high profile media. So Caitlin Flanagan writing in The Atlantic, Barry Weiss writing in the New York Times, provocatively condemned Grace's story as really this idea of deeply trivializing what Me Too stood for. The debate, as I say, it exploded, and it was very quickly framed as generational. There was this idea that it was millennials versus second wave feminists. And the debate, not only was it kind of reduced to this generational story, but it also quickly turned very, very nasty. Katie Way, who was the author of the Aziz Ansari Grace story in babe.net, somewhat famously called the CNN anchor Ashley Banfield a burgundy lipstick, bad highlights, second wave feminist has-been. Punches were not being pulled. Younger feminists blamed second wave feminists for, well, pretty much everything. And second wave feminists, not to be outdone, told millennials to grow up and learn how to call an Uber. Ouch, it was game on. Now, not all feminists, of course, joined in this generational narrative. Many others tried to suggest that there were other kinds of fault lines going on here, but these voices were largely lost in both social and mainstream media, where the preferred narrative was and often is a catfight between women, but in particular, a catfight between the generations. Now, there's so many ways in which this generational narrative really didn't make any sense. It didn't make sense to me at all, not the least of which was the actual age and generation of the women who were fighting, who simply didn't correspond to these two generations. Some of the, some younger women were being critical of Me Too, some older women were supporting Me Too. And of course, there's the third wave, which was not even mentioned here. So also to say nothing about the assumption that women within each of these generations were in some ways homogenous. Second wave feminism, if we've learned anything from our history, and this is sometimes forgotten, agreed on very, very little. And so the generational narrative just struck me as not particularly useful. It didn't, for me, help explain what the real disagreements were that were going on here. Now, admittedly, when you're a hammer, everything looks like a nail. And so what did I see? I saw sex wars exploding all over the place. I thought that it would actually be much more helpful to situate the debates that were emerging, both in the immediate aftermath of the Aziz Ansari story, but also the other debates that were emerging within feminism, between and amongst feminists about Me Too, to situate these debates within the feminist intellectual history of the sex wars. For me, this would allow us to better understand the nature of the disagreements, both past and significantly present. I think that that doing this is also crucially important, because I think that it's only in truly grasping the nature of the disagreements that we can begin to find a way to move past them. And that is also very much part of my project, is this idea of trying to think new ways to think beyond the sex wars, really to stop just repeating them over and over again. Okay, so then back we go to the sex wars. So what were the sex wars? The sex wars were these highly polarized and antagonistic debates in the 1970s and the 1980s that focused all around questions of sexuality, focusing not exclusively, but in particular on pornography. There were also debates around various other things, whether it was domestic violence or sex work, but it really focused on this question of pornography. And here my discussion is in a kind of, Wikipedia nutshell, which of course risks simplifying both sides. But on one side were radical feminists who saw sexuality as a site of women's oppression, as one of the most significant sites of women's oppression. They saw women as victims of sexual violence, and they increasingly, over the course of the 70s and 80s and these sex wars, turned to law as a way to remedy this sexual violence, in this moment in time in terms of trying to redress the question of pornography. On the other side were a very different group of feminists known as sex radicals. Both sides have various names. These are also known as sex positive feminists, but we'll call them sex radicals, who didn't want to see sexuality exclusively as a site of danger, but also wanted to see sexuality as a site of potential pleasure for women. They saw women not only as victims, but also as agents, as capable of exercising agency in their lives, albeit in conditions of some degree of oppression. And they very much opposed the use of law, here opposing the use of law, particularly to address pornography. Now, these debates were fierce and divisive. Organizations fell apart around these sex wars debates. There really was a reason it was called war. Now, the debate over pornography itself subsided in the mid to late 1980s. It lasted a little longer in Canada, but by the early 90s or so, the debate over pornography really had subsided. But the underlying disagreements around sexuality, around women's agency, and around the role of law have never really subsided. They have stayed with us, and I think that they have, these debates have reared their heads many times when feminists begin to disagree. Many have suggested, some have suggested more recently that the sex wars are back. Now, I don't think this would be the first time that the sex wars came back. In fact, I think they came back in the 1990s around questions of campus sexual violence. They came back again. So as shown in this slide is the cover of a New York Times Magazine article featuring two of the doyens of feminist legal studies in the United States, Catherine McKinnon on the one hand, Janet Halley on the other, featuring them as the main protagonists and arch enemies on the question of regulating sexual violence, particularly on college campuses. Now, I would be remiss if I didn't say something about the fact that, there's a whole history of Marlee having some run-ins with the person on the left-hand side of the screen. That, though, would be a topic for another day. And, one day I would like to write the history of those entanglements. But, back to the topic at hand. So the new sex wars. So the new sex wars were circling around a very different set of issues. So it wasn't about pornography or sex work or the sexuality issues that were being fought about in the 70s and 80s. Now it was about sexual harassment and sexual assault. And this already made the sex wars then quite different than in the past. So in the past, one side was against pornography and the other side was for it. In these sex wars, it's not as if either side is in favor of sexual harassment or in favor of sexual assault. Rather, it's that the sides disagree on how broadly to define sexual violence, how to define sexual assault, how to define sexual harassment, and what the role of law should be in redressing it, what the law should actually look like in redressing it. And it is on this issue, particularly in relation to debates in the United States around Title IX, that McKinnon and Halley have been going at it in terms of adopting these very, very, very different positions. They also both teach at Harvard, though I'm pretty sure that they keep them in separate buildings. So in my work, I try then to tease out the ways in which these current debates are once again dividing in exactly the same ways as the original sex wars, dividing around visions of sexuality, dividing around questions of consent and women's agency, and dividing around questions of the role of law. On one side, and here, on the left side of the screen, we have the inheritors of radical feminism. Now, not incidentally, McKinnon was around the first round in terms of the first round of the sex wars. And she is still, although she is not one of necessarily the most significant interlocutor in the current ones. But here, the inheritors of radical feminism see sexuality again as really dangerous, women as victims of sexual violence, and arguing in favor of stronger laws. On the other side, the Janet Halley side, here we have the inheritors of the sex radicals who worry about overly conservative visions of sexuality coming in definitions of sexual violence or sexual harassment and sexual assault, who want to keep room for women as sexual agents, and who worry about overly broad laws, particularly, though not exclusively, any kind of reliance on criminal law. And so what I start to do is, paint this picture of how the sex wars were already coming back pre-Me Too, before Me Too even erupted. And then I move forward to look at the way in which these debates around sexual violence, sexual harassment, sexual assault have then informed the feminist debates, specifically in relation to Me Too. These very debates that were emerging between feminists and Me Too once again break down on the very same lines. So now here, this is, now, Me Too, of course, was a movement all about sexual harm. And all the feminists, the Me Too feminists, and then what I refer to as the feminist detractors, oppose this sexual harm, sexual violence, but of course they disagree over what constitutes sexual harm and what the role of law should be in redressing it. So here, this is at the risk of grossly oversimplifying, even by Wikipedia standards, the two different sides. And really, there's nothing absolute about these two sides. It's really a question, it's a matter of degree and emphasis. So what I think that we see is Me Too feminists, once again, the intellectual inheritors of radical feminism, with its greater emphasis on sexuality as a site of danger. In contrast to the feminist detractors, who also want to, the intellectual inheritors of sex radical feminism, who also want to keep room for the idea of sexuality as pleasure. Now, in its current moment, neither side completely denies the other, but it's a question, it's a matter of degree and a matter of emphasis. So on questions of consent, so Me Too feminists seek broader understandings of consent or the absence thereof, whereas the feminist detractors are worried about some of those definitions because they want to make sure and leave room for the idea that women can also exercise some degree of sexual agency. Now, when it comes to law, it's a little more complicated. It's a little more complicated because Me Too did not emerge as a legal movement. It did not emerge with any kind of a legal agenda. In fact, it was a performance of law's spectacular failure. Me Too really emerged as this extraordinary performance of law's utter failure to prevent sexual violence or to redress sexual violence. The sheer ubiquity of sexual violence in our world showed that all of these laws that have been passed over the years have really been doing very little. So, it didn't really, clearly have this legal agenda. But I think that that we can see sort of and alongside the broader feminist debates that were already emerging, a la McKinnon and Halley, that we can see these debates around what the appropriate use of law should be in regulating sexual harm. Again, one side, more the McKinnon side, calling for more and better law, calling for broader definitions, calling for better enforcement. On the other side, there are those then who are more concerned about law's overreach, particularly the criminal law. Now, it often comes back to questions of the potential abuse of state power under the criminal law. And here, this is work that is very much building on the work of Black feminists and other feminist critiques that really worried about, really were beginning to point out and worry about problems not only of the carceral state in general, but concerns about who gets targeted by the criminal law. And their work pointed out, and has been pointing out for some time, that it is, when you use the criminal law, it's Black people, it's Indigenous people, it's poor people, it's the intersection of those who are disproportionately targeted and incarcerated That is the case in Canada, but even more so in the context of the United States, where many of these debates, of course, were taking place. Now, this was a critique that Marlee was making well before it became fashionable within mainstream feminism regarding, for example, child welfare law and its horrifically disparate impact on Indigenous people. So this is then, part of the picture that I have tried to paint here to suggest that these are very, very similar debates, effectively the same debates going on in the context of Me Too, in the context of contemporary feminist debates around the regulation of sexual harm that we saw back in the heyday of the sex wars of the 1970s and 1980s. I think we can begin to see, when we zoom out a bit, that the two sides focus on very different kinds of harms. On one side, there's a real focus on the harms of sexual violence and law's failure. The other side is there's a real focus on the harms that comes from law's regulation of sexuality, consensual and non-consensual alike. So this is the mapping that I do in much of the first part of the book, showing that feminists are still having the same fights that they've been having over and over and over again for 50 years. Now, we might reasonably ask, so what? So what? I love a good map. I really like a good map, but I don't want to end things with a map. What I'm interested in then is, how can we think about moving beyond this? How can we break out of the vice grip that the sex wars and their divisions seem to have on us? How might we do things differently? How might we find a way to break out of this endless repetition of the debates about sexuality, agency, law? Now, here is where I turn to the work of the late, great Eve Sedgwick, whose groundbreaking work did many, many things in social theory. But one of the things that I pick up here and I try to use is this idea of reparative reading. So Sedgwick wrote about and argued in favor of a different kind of reading practice. Now, I could go into all kinds of fancy theory, but I'm not gonna. What I'm gonna say is, she suggested that instead of always looking for meaning underneath things, instead of always looking for what's hidden beneath, and to be, it was called a hermeneutics of suspicion, that we're always, really, really paranoid. We're always trying to find what lies underneath. But sometimes we should just look to see what's in plain sight. And we should also, she said, try to read beside each other, rather than reading against or underneath, and often against. We should try to put things beside each other. Now, what does that mean? Well, what might be revealed if we tried to read these different feminist claims beside each other rather than against each other? What might we see, understand, feel if we accepted the possibility that both sides had something to tell us, and that we could hold both of those claims in tension with each other? Now, the best way that I've always found to describe the exercise of reading beside is with the bunny and the duck. So I love the bunny and the duck because it's about things that are contradictory. With the bunny and the duck, you can only see one at a time, right? You can see the bunny or you can see the duck. You can't see them both at the same time, but you know that they are both always there. When you see the bunny, you know that the duck is still there. When you see the duck, you know that the bunny is there. And so for me, the idea of reading beside is this idea of trying to hold these two things in view, although sometimes it's hard to do it at the same time. And so then I come back to the competing sets of harms, to the two different competing sets of harms. So we have on one hand, the harms of sexual violence and its underregulation, the way in which there is just a huge amount of sexual violence and the huge harms that causes in women's lives, and law's utter failure. On the other hand, we can also hold on to the harms that have come from trying to regulate sexuality, as I say, consensual and non-consensual alike. So what I have been trying to do here is, and what I try to do in the latter part of the book, is think about what a reparative approach to regulating sexual harm might look like. What might it look like if we could read the claims of the sex wars beside each other? If we could read Me Too feminists and feminist detractors beside each other, what might that look like? And here, once again, I return to the work and I try to center the work of Black feminists, including the work of Tarana Burke's Me Too movement, the work of a series of abolitionist feminists, particularly Angela Davis, Beth Ritchie, Ruth Wilson Gilmore, some of whom are represented in the slide, to really try to recenter their work, and in particular, their critique of the criminal justice system, to use their work as a way to help us think about displacing the centrality of criminal law without in any way abandoning a commitment to eradicating sexual violence. And I think that there's so much to be learned from the work that is being done by many of these abolitionist feminist movements right now, in terms of trying to decenter the carceral state, in trying not to turn to criminal law, but finding other ways to take sexual violence really seriously. And one of the things I think that it helps us do is to realize our choice is not between criminal law and no law, but rather to think about various other forms of law or law-like things that may be at our disposal. And loosening criminal law's hold on the definitions and the regulation of sexual harms, I think could go some way to allow for deeper feminist conversations that can address sexual harm without endorsing this criminal carceral state. Now, it goes beyond what I can address in my few minutes remaining today, but I think that we can begin to imagine alternative modes of regulating, to think really differently, to leave the criminal system behind and to think about alternative ways to address sexual harm that can better promote accountability and cultivate repair better than anything the criminal justice system has ever offered us. And I have a whole critique around, it may be hard to imagine giving up the criminal justice system and giving up the criminal law, but when we look at what the criminal law has done, it is so very, very little. And so I take great inspiration from those who are thinking about alternative ways, whether it's restorative justice processes or transformative justice processes, that are looking for alternative ways to demand offender accountability and to encourage survivor reparation and to develop forms of reintegration. But breaking with the sex wars also, I think, requires not only that we think reparatively around the regulation of sexual violence, but I think it also requires that feminists address our emotional investments and responses around disagreement. Particularly, we need, I think, to address a series of questions around, or a series of issues around emotion and affect. So in the final pages of my book, I actually try to explore what a reparative approach to feminist disagreement might look like. To break free of war, the language of war, where we need less people warring, we need more conversations and interlocutors. But I think that we need to think more productively about how to engage in disagreement. As feminists, we've never learned this. We've never learned really to address disagreement with one another. Disagreement has all too often devolved and all too quickly devolves into a sense of betrayal, outrage, anger. In fact, in going back to the archives, when I reread the original Sex Wars, and then even following it up to reading many of the materials today, I was so struck by the emotions that are seared into the pages, into the letters to the editor, into the newspaper articles. The emotion, the anger was just leaping off the page. And here again, I once again rely heavily on the work of Black feminists, from Audre Lorde to Tarana Burke, who have been encouraging us to think differently, to craft our anger in more productive ways. Tarana Burke tells us that we can be more than our anger. We have reason to be angry. You can't go out into the world today and there's something wrong with you if you're not angry, but that we can do more than that. That we need to be more than our anger. We need to lean into our healing. And she argues we need to cultivate joy in our lives. To this, I would add even more so, I would say that we also need to do so with more than a little hope. There are a number of feminists, Eve Sedgwick herself talked about reading with hope, others who are encouraging the idea that, and particularly as we live in these deeply despairing times, these feminists, and as I say, reading with Sedgwick, reading with Tarana Burke, that we need to lean into an idea of hope, to the idea that we can learn to do things differently. We can use our imagination, we can work together. We might not disagree, we might not agree, but we can find more productive ways to disagree. And I would say, and I come back to Marlee, this is exactly what Marlee always did in her work and in her life. She did it better than most of us. She certainly did it better than I ever did. She crafted her anger. She put it to productive use. She modeled disagreement with respect and empathy. She always allowed for, she worked for, she was so committed to future possibilities of joy and hope. It has taken me years and years to catch up to where Marlee was. I miss her so very deeply. And I will stop there.
Thank you so much, Professor Cossman, for a very inspired and inspiring talk. Good evening, everyone. Thank you for being with us this evening. My name is Régine Tremblay. I'm an assistant professor at the Peter A. Allard School of Law and the director of the Center for Feminist Legal Studies. I would now like to invite some questions from the audience. If you haven't done so already, you can use the Q&A button on the bottom panel of your webinar screen to submit any question that you may have for our speaker. So please send your questions forward. Maybe while you take a few moments to type in your question, I will offer a first comment and a first question to Professor Cossman. So thank you again for your talk. Some observers has referred to this Me Too phenomenon and movement as a fourth wave within feminism, and acknowledging, of course, the limits of thinking about feminism as of waves. I would like to hear your thoughts about whether or not this movement in a few years would be seen as different and distinct enough, or so that it can indeed be qualified as a fourth wave feminism.
Thank you, Regine. So that's a great question, and it's one that I address just a little bit in the book. So one of the things I talk about is this idea of feminist waves. And there's a way in which the idea of feminist waves is, it's overly simplifying of various stages of feminism. And yet, I think it does capture something of different generations of women with different sets of concerns and different sort of different sensibilities that move forward at different times. So the third wave came out very much in reaction to the third wave feminist perception of what the second wave was. Now, second wave, by virtue of the sex wars itself, like the second wave feminists really didn't agree on very much. In fact, they, disagree about more than they agree. There's the sex wars, there's Black feminists challenging the whiteness of second wave. So, I mean, there's already so much going on in second wave, but third wave feminists actually really sort of announced their arrival by not being second wave feminists. Like we're here, we're different. And it was actually, I think it was Rebecca Walker, Alice Walker's daughter, who very much announced in an issue of Ms. Magazine that, now we're here, we're the third wave. The fourth wave, so a number of people have been talking about the fourth wave of feminism since the late aughts. Jessica Valente, feminist writer about town, said in 2009 that the fourth wave was already here. The fourth wave was very much a sort of a younger group of feminists who were coming into feminism with a different set of sensibilities. But one thing that was really interesting about it is folks who are starting to write about the fourth wave now, the fourth wave didn't emerge in a kind of, kill the mother way that generations of feminism has sometimes done. It didn't announce itself against the third wave. It kind of arrived as, we're here now and here are our issues. And, the fourth wave is online. It's the digital wave. It is the first generation of feminists, of course, who have grown up as people online. So I think that there very much is a fourth wave of younger feminists, but I say that with a view to the limitations of the very wave metaphors that we use, because I think that wave metaphors do risk simplifying the differences and really important differences within each generation.
Thank you so much. So we have a question in the Q&A box, and the question goes as follows. Can you share some examples of what non-incarceration options exist to provide justice, reparations, and more to victims of sexual violence?
Oops, no, I just muted myself. So here I am taking, there's a range of ways of thinking about alternatives to the criminal justice system. There are ways of thinking about, restorative justice models, for example. Now, restorative justice is a term that now means everything and as a result, nothing. Restorative justice models might be something that can be brought on to say the end of a criminal justice process, that it becomes part of sort of the sentencing moment, that we bring in a restorative process, but really attached on to the end of a criminal justice system. It could be its own process. And the thing that is really different about restorative justice models is the idea that you bring the stakeholders together, and you try to promote offender accountability. It's not about offender punishment. So if we move into the criminal justice system, it is very much a mode of punishment and incarceration, but it is intended to encourage accountability, to get offenders to admit wrong and to take accountability for that. There are various things that it could involve. It can involve apologies. It can involve community work. It could involve all sorts of things. It could involve mandatory education. It's also about then promoting and thinking about what victims/survivors actually want and actually need. Part of the problem with the criminal justice system is, as soon as it moves into the criminal justice system, it is no longer about what the survivor victim needs. There is really only one outcome. Well, there's many outcomes, but the only thing that will allegedly vindicate the victim survivor is to convict and then ultimately incarcerate. So here it's a way of thinking about, what do victims actually want? And when we stop and listen to victims and survivors, sometimes what they want is accountability rather than necessarily incarceration. There's those who go further. Transformative justice, and that is the type being espoused by a range of abolition feminists, are working with there's grassroots organizations working in a number of communities all around the United States that are trying to find ways to work within local communities to avoid the state altogether, precisely because they do not trust it, and they have very good reason to not trust it. To find ways to bring together the stakeholders, the offenders, the victims, the families, the communities, and find other ways to address not just what happened, but why did it happen? How can we begin to address root causes? How can the whole community begin to move forward, taking responsibility for the sexual violence that has occurred? And this is, again, it's a more transformative model. It's a more transformative model that is looking to not just piggyback on the back of state-based approaches, but is actually looking to take things into the community. There are many, as I say, many feminist groups in the United States that are doing this, abolition feminist groups. Insight is a very big one, but there's many others who are trying to do this transformative justice abolition work. And I think that it behooves us who are working in and around sexual violence to think about, we might not start by completely abandoning the criminal justice system or all law, but what can we learn? What can we think about? How could we, move away from the exclusive reliance on the criminal justice system and think about reliance on civil law, on the civil justice system? Now, we could have a whole other talk about the inadequacies of the civil justice system, but how might that work differently? How might consensual dispute resolution processes be brought to bear in ways that might be able to better redress the problem and actually provide a better sense of healing and despair for the survivors of sexual violence?
Thank you. So we have two more questions and a few more minutes. So I will read the two questions and you can answer them the way you'd like. I think that there's one connected to the answer you provided already. So the first question goes as follows. I am a retired BC Crown Counsel, having prosecuted sex crimes for 3 decades. I can confirm that the law and the criminal justice system is hopelessly behind and utterly inadequate to combat crimes of violence against women and children. Do you see any realistic prospect or have any optimism that the law, courts will be of value on this issue? So that's the first question. And the second one, a brilliant lecture. Thanks, Brenda. Your analysis is focused primarily on the US debates and scholarship, but obviously is also about a global movement and debates. Do you think of your analysis as about the US specifically, or addressed primarily to a US audience, or is it equally applicable in other global contexts?
Okay, so let me address the second one first, because I think it's in some ways easier. So this book is unapologetically American. It is absolutely rooted in an American context, which sadly is also a Canadian context, right? Because the whole Me Too movement, our experience, our Canadian experience of Me Too was so deeply influenced by the American nature of the movement. So it is very, very, very much speaking to a US, and I don't even want to say North American, but US and Canadian audience. It seems to have had some degree of success in translating to, say, similar debates occurring in England. I would not want to suggest that it would necessarily have a lot of purchase moving beyond that. Now, the idea of finding ways to move beyond binary debates that feminists are having over and over again, that seems, that it could be helpful, but far be it from me to make any suggestions about how this ought to work in contexts outside of my own. Having said that, I'm actually a commentator on a conference tomorrow about Me Too Asia. Reading these absolutely fascinating, fantastic papers about the Me Too movement in India and Pakistan. but I don't think that, I mean, I certainly wouldn't take my, my mapping or anything and try to apply it outside. I think that the idea of approaching things more reparatively could be helpful, but there may be other ways to break out of binary thinking in other contexts that don't require that. Oh dear, do I have any optimism about the criminal justice system or even the justice system in general? So the short answer is no. No, I don't. But I am trying to end on a message of hope. I think that we all have to think more imaginatively than we do. And I think this is particularly a problem. There's a kind of occupational hazard of being a lawyer. What else could we do? What else could possibly be done? Because these are the systems that are there. I think we really have to rethink them. And we don't just, add little bits and pieces necessarily, but we need to fundamentally rethink how we address issues. And it requires imagination. It requires us being able to literally imagine that things could be different. And so, do I think the current system with a few twists and reforms is going to be very different? No, I don't. But I do place some degree of hope in work being done to imagine that we could do law differently.
Thank you so much, Brenda. Unfortunately, we are out of time for further questions. Thank you all for your participation, and a special thanks, obviously, to Professor Cossman. I will now pass the virtual microphone back to Dean Findell for closing remarks.
So thank you. Thank you, Brenda, for the wonderful comments, and thank you, Virginie. So we are at the end of tonight's event. It was a very engaging discussion. Thank you to Professors Virginie Tremblay and Margot Young for your assistance with the program as well. And a special thank you to the Kline family for being here with us today, and for our viewers for joining us this evening and including us in your already very busy schedules. I hope this was a valuable session for all of you. Please stay safe and healthy, and have a good evening.